Hello. Before I get into my presentation this year, I would like to gratefully acknowledge a number of people who for many years have made Constitution Day possible with their tireless efforts behind the scenes. First, Chair of the Social Sciences Department, Dr. William Eric Davis. Also, Chair of the Events Committee, Dr. Robert O'Mara. And also Dr. Kenneth Fernandez, whose important efforts behind the scenes made it technically possible to have these Constitution Day presentations year after year. Now, with all this said, let's get into my presentation for this year, NYSRPA versus Bruen, a very important Supreme Court case. I'm Dr. Michael Hart, and this is a presentation for Constitution Day at College of Southern Nevada on a very important case, New York State Rifle and Pistol Association versus Bruen. The Second Amendment states a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Now, the first clause of the Second Amendment, that's the one that says a well-regulated militia being necessary to the security of a free state, this clause is known as the prefatory clause. It's an introductory clause. It sets up or explains the meaning of the second clause that follows it. And it is flexible enough to allow either expansive individual gun rights or narrow gun rights that are limited to the service in an organized militia. In other words, the interpretive question here that's inherent in the ambiguity of the prefatory clause of the Second Amendment is, does one have to be a member of some kind of organized militia in order to possess the right to keep and bear arms, or is the right to keep and bear arms an individual right, not connected to service in any organized militia? So against the backdrop of brutal gun violence and rapidly increasing number of guns in the country, the first quarter of the 21st century became a battleground over the scope of Second Amendment rights. This particular case, the NYSRPA versus Bruen case, is really the third in the great trilogy of cases in the first quarter of the 21st century pertaining to gun rights. In DC versus Heller in 2008, the Supreme Court held for the first time that the right to keep arms is an individual right. Dick Heller was a security guard in Washington, D.C., and Washington, D.C. denied him the right to register his gun, and you could not even keep, much less bear, a gun, an unregistered gun in your home. So he challenged the DC regulation, which made it unlawful to keep an unregistered weapon, just to keep it in your home. So the fundamental question in Heller was whether or not the right to keep arms is an individual right, and the Supreme Court, in a very close 5-4 decision, answered this question in favor of individual gun owners and said, well, it's an individual right. Then the next case is McDonald versus Chicago. This case was decided in 2010, and it pertained to the status of the Second Amendment right to keep and bear arms. Not all rights are created equal, or at least that's what the Supreme Court told us in its 1937 decision, Palco versus Connecticut, which established the doctrine of selective incorporation, meaning that certain rights are more important than others. Certain rights are fundamental and others are not. And fundamental rights restrain not only the national government, but state governments as well. And the reason why they do is because the Due Process Clause of the 14th Amendment has the word liberty. It says that states shall not deprive its citizens of life, liberty, or property without due process of law. And then the question becomes, well, what is meant by the word liberty, the Supreme Court essentially answered that question by saying, well, these are the fundamental rights that are stated in the Bill of Rights. So in McDonald versus Chicago, the Supreme Court makes the fateful decision to recognize the Second Amendment right to keep and bear arms as fundamental, making it applicable to state and local governments. And finally, we get to NYSRPA versus Bruen. And this case held that a person does not need to show a special need for self-protection to receive a license to carry outside a home. This holding invalidated New York state law that required a person to show a special need to carry a firearm. So special need was limited to individual circumstances, such as being on the receiving end of death threats. If you worked in a relatively dangerous job, like being a cab driver in New York City, or if you lived in a particularly high-crime neighborhood, this would not qualify you to obtain a license to carry. Okay? So you needed to really show particular circumstances that you in particular faced some kind of need to carry a firearm in public. Now, to be fair to the state of New York, this regulatory regime allowed concealed carry for the purpose of hunting and target practice. It's just if you wanted to carry outside these activities, if you wanted to carry concealed for the purpose of personal protection, then you would need to show special need. And this regulatory regime was first adopted by New York State in 1911, and then it would be amended several times, and the last major change occurred in 1913. So by the time the Supreme Court gets this case, there's 109 years of this regulatory regime existing in the state of New York. Now, what the court said with regard to its the basics of its reasoning is that New York State regulatory regime is unconstitutional because it denigrates the Second Amendment right. And the court pointed out that no other right listed in the Bill of Rights requires the showing of a special need in order to be exercised, right? So if you want to exercise freedom of speech, you don't first have to show a special need in order to exercise it. It's a right that belongs to everyone. The second point is history and tradition, and this is what really is emphasized in the court's opinion written by Justice Clarence Thomas. Thomas argues that New York State law is not supported by history and tradition of firearms regulations in this country. Now, I think that the first argument is a strong one, about special need, right? You shouldn't need to show special need in order to exercise a right that is specifically stated in the Bill of Rights. The second argument, and that's the one that the court spent most of its time on, I think is problematic, particularly because of the way that Justice Thomas went arguing it. Really, I thought that reading it is a bit surreal because there are many examples of strict regulations of firearms, including the fact that during much of the 20th century, the majority of states had a regulatory regime similar to that of New York, even though they do not have now, but they did. And the court would say, well, these are too new. These are too new, so they do not count. At other times, the court would say, well, there are regulatory regimes that are similar to that of New York, but they only apply to a small percentage of population. So the court seems to cherry pick its evidence, and this cherry picking is what allows it to reach the conclusion that New York state laws, regulations are actually not constitutional. in her concurring opinion, which read, in my view, more like a dissent, Justice Amy Coney Barrett stated that the court's opinion was not really systematic enough. It lacked the methodology to differentiate between rights that are, regulations rather, that have been truly established, truly consistent with history and tradition, and those that should be discarded as not being in true accordance with tradition. So her opinion was actually very good in this regard, in pointing out what was wrong was the court's opinion, even though she joined the court's opinion and, of course, the court's conclusion as to what happened here. Now, the dissent was written by Justice Breyer. Justice Breyer opened with danger of firearms. And if you want statistics, if you want to know how dangerous guns are, Breyer's clerks did an excellent job on their research. And so much so that in his opinion, in his concurring opinion, Justice Alito replied to Breyer. So more than concurring with Thomas's court's opinion, Alito actually criticized Breyer for including too much by way of gun statistics and saying, well, much of it is irrelevant. He would say that, the dissent tries to point out how many people needlessly die due to suicide because of guns, how many drive-by shootings there are because of guns. None of that is really applicable, according to Justice Alito. So back to Breyer. Breyer said what I have said, that the court basically cherry-picks its evidence. And also Breyer points out that in his view, New York State's licensing regime should not be considered like something that you need a special need to exercise your right, but rather as part of the normal balancing test. In other words, no right is absolute, no matter how fundamental. Any right can be limited, right? So individual rights must be balanced against the interests of society. And so when there is an important or a compelling governmental interest, then certainly government can impose restrictions. For example, Breyer correctly notes that this Bruen decision by the court does not prohibit the states from forbidding guns in sensitive places, like college campuses, right? Why? Why can a state forbid the carrying of guns in sensitive places? Well, because it has to balance the right to bear arms with safety of the people. And the safety is a compelling governmental purpose. And so presumably the state would need to have a compelling state interest and narrowly tailored means to do so. So Stephen Breyer here, this is one of his last cases before he is stepped down, one of his last opinions, really disagrees sharply with the court. And Breyer views New York State's regulatory regime, however restrictive it may be, as a necessary step that the state takes in order to balance individual right to keep and bear arms with the state's interest to protect the lives and safety of its citizens. Now, this was a 6-3 decision, unlike the 5-4 decisions in Heller and McDonald. One thing that has changed here was the death of Justice Ruth Bader Ginsburg and her being replaced by Justice Amy Coney Barrett. So the balance on the court in terms of conservatives to liberals, and more to the point in terms of the Second Amendment rights, has moved to 6-3 from 5-4. So it became even harder, really, to overturn it. If you're looking forward to any change, don't look forward to it any time in the foreseeable future. It may take decades until this changes, if ever. And I do think that in order to overturn NYSRPA versus Bruen, the court would have to overturn Heller. Because if you accept Heller as a valid precedent, then I think the conclusion in Bruen follows. In other words, if you accept the conclusion, the most important conclusion of Heller, that the right to keep and bear arms is a fundamental right, and it's individual. I'm sorry, that it's an individual right, right? It's an individual right. Then the Bruen decision really follows logically, and any constitutional battles in the future will, if they ever come up, will revolve over that issue, over the meaning, again, of the prefatory clause of the Second Amendment. Now, as far as what the states can do going forward, and some of them have already started doing so, is to impose discretionary requirement, not special need requirements, because those we now know are unconstitutional, but discretionary requirements. For example, New York State has already passed laws that require people to obtain training, very lengthy training, before they can get a permit to carry concealed, and also to renew it every few years. So this, but by the time that you take time from work to apply for permit and get the training, this can add up to hundreds or maybe even $1,000 every 2 to 3 years. So poor people would be priced out from carrying concealed guns in public for protection, and this will become a right for middle class and for the rich. So something along these lines will also be adopted, I think, in other states that are not particularly open to individual carry for protection, right? So while the special need requirement is gone, the discretionary requirement will be implemented. Okay. So bottom line is this case, the Bruen case, is a big win for individual right to carry, but for practical purposes, we don't know, because again, the discretionary requirement will limit the ability of the poor, at least the poor people, to do so. The number of guns in the country remains very high. It's about 400 million, with the population of 336 million. So there's almost 6 guns for every 5 people, including babies. A controversial decision, but a clear constitutional victory for individual right to conceal carry for self-protection. Thank you.